It's said that Britain is a nation of animal lovers, and whilst that may not be entirely true, it's certainly true that we have some of the highest populations of dogs, cats, and other pets in the world. And this inevitably means that pets are often caught up in disputes over who should keep them when their owners separate. Most pets are, of course, cherished members of the family, such that it will often be the case that both parties to a separation or divorce will want to keep them. Hopefully, the issue of who keeps a pet will be sorted out by agreement, whether directly between the parties or by some other means, such as mediation. But what if they can't agree? How is the matter then resolved? In this article, we will look at how the law treats pets in a divorce or separation, and will then examine a recent example case. We will also look at how the law may be reformed in the future. As just indicated, couples should try to agree between themselves what should happen to any family pets in a divorce or separation, and various arrangements are possible, not just that one party keeps the pet to the exclusion of the other party. Some couples agree to treat the pet in a similar fashion to a child, sharing its time between the two parties. But what if a couple cannot agree who should keep the pets in a divorce or separation? Then they will need to ask the court to sort the matter out. This occurs most frequently in divorce proceedings when a party asks the court to deal with the matter as part of an application for financial remedies. And when such an application is made, the law as it currently stands in England and Wales will look at pets essentially in the same way as it would view any other chattel, such as a car or an item of jewellery. Chattels are usually dealt with by the court by reference to their value, taking into account such matters as how and why the chattel was purchased and which party possessed it. Thus, for example, one party may be awarded a chattel or allowed to keep the chattel as part of their divorce settlement. And if that is not appropriate, then the court might order all of the chattels to be sold, with the proceeds of sale being divided between the parties. All of which may seem rather callous so far as pets are concerned, but there can be a difference between the strict law and the way that a judge approaches the matter of what should happen to a family pet. A clue to that approach came from a High Court case in 2011 in which the judge stated, "I do not consider it appropriate to make any order in respect of one of the dogs because on the evidence I have heard, they would seem to have been principally looked after by the husband." In other words, when it comes to deciding who should have a pet, the court will consider other factors such as who looked after the pet. We'll now examine this more closely by looking at a recent example case. There are actually very few reported cases where the court dealt with the issue of who should keep the family pet on divorce, but a divorce case that took place in the family court in Manchester last December provides a very good example. In the case, the family dog, a female golden retriever, had been purchased jointly by the family, the husband, the wife, and their daughter, in May 2022 for £1,200. The couple separated in November 2022, since when the dog had been looked after solely by the wife and been a pet for the two children of the family who lived with the wife. From this, it would seem clear who should keep the dog, but in February 2024, the husband attempted to steer matters into his favour by registering the dog as a disability support dog required by him to assist in relation to his anxiety and depression. And then in December, the husband forcibly took the dog from the matrimonial home whilst the grandmother was out walking the dog. The dog ran off, and the grandmother witnessed the husband dragging her into his car from the family home, where the dog had run back to. Following this, the husband was arrested by the police, and the dog was returned with damage to her paws from being dragged away by the husband. Unsurprisingly, the children were incredibly upset over this incident. Deciding who should have the dog, the judge found that she had never been purchased as a disability support dog as the husband alleged. The husband had only registered her in an effort to support his case that he should have the dog. The judge went on to say that in her view, who purchased the dog was not as important as who the dog saw as her carer. She found that the dog's home was with the wife and she should stay there, particularly as it would be upsetting for both the dog and the children if those arrangements were to be changed. Accordingly, the judge ordered that the wife should retain ownership of the dog. As might be imagined, there are many people who aren't happy with the way that the law currently treats pets on separation or divorce. Some are therefore calling for a change, particularly as the law does now specifically recognise that some animals are sentient beings. Some campaigners have even launched a UK government petition calling for legislation to make pets' welfare the paramount consideration when courts resolve disputes over their ownership and possession, and to recognise a pet's true value as being the value to its owner, not just its open market price. Whether the petition receives sufficient signatures for the government to respond remains to be seen. However, other countries, including France, Spain, and Australia, have updated their laws to ensure that pets are protected on divorce and separation. To give an indication of how this might happen in England and Wales, we will conclude this article by looking briefly at how the law was recently reformed in Australia. Last December, the Australian government passed the Family Law Amendment Act 2024. The Act prescribed companion animals, pets, as a specific type of property to which a set of considerations may apply when the family law courts determine what order, if any, should be made in respect of the ownership of the companion animal as part of property division. The Act defined a companion animal as an animal kept by the parties to a marriage or either of them, or the parties to a de facto relationship or either of them, primarily for the purpose of companionship. Animals kept for some other purpose, for example in connection with a disability or for agricultural purposes, are excluded from the definition. The Act then states that in divorce settlement proceedings, the court may order that only one party to the marriage is to have ownership of the companion animal, or that the companion animal should be transferred to another person who has consented to the transfer, or that the companion animal be sold. In deciding what order to make, the court is to take into account the following considerations, so far as they are relevant. A. The circumstances in which the companion animal was acquired. B. Who has ownership or possession of the companion animal. C. The extent to which each party cared for and paid for the maintenance of the companion animal. D. Any family violence to which one party has subjected or exposed the other party. E. Any history of actual or threatened cruelty or abuse by a party towards the companion animal. F. Any attachment by a party or a child of the marriage to the companion animal. G. The demonstrated ability of each party to care for and maintain the companion animal in the future without support or involvement from the other party. And H. Any other fact or circumstance which, in the opinion of the court, the justice of the case requires to be taken into account. As will be seen, this is much wider than the law as it presently stands in England and Wales, specifically directing courts to take into account such relevant matters as to who cared for the pet, whether a party had ever abused it, and any attachment that a party or child has to it. It is to be hoped that the law in this country may in future have some similar provision. For now, however, we are left with the law as it stands at present. If somebody close to you would benefit from this episode, please do share it with them. And in the meantime, leave this episode a like and subscribe to our channel so that you don't miss any of our upcoming episodes in the future. If you would like to get in touch or take a look at some of our other blogs where we cover various topics, please visit our website at walkfamilylaw.co.uk.